Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to episode number 116 of eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Each Friday morning at 11 a.m. Eastern, I host an episode of eDiscovery Leaders Live where I get the chance to chat with luminaries in eDiscovery and related areas. For past episodes, go to the Reveal website at revealdata.com. Select Resources, then select eDiscovery Leaders Live. My guest this week is Erin Toomey. Erin is a Senior Director at Epiq, leading the Antitrust and Competition Practice Group, and is based in the Washington, D.C. office. With over 15 years of experience, her primary focus is review and production management in litigation, government, and internal investigation cases. In addition to these services, Erin has extensive experience in the complete EDRM lifecycle and has provided support and strategy development for collections, processing, content, and privilege review and productions. She has managed projects including international cases with complex data privacy concerns spanning multiple jurisdictions, as well as civil litigations of varying sizes. Erin is a graduate of Wake Forest University, where she focused on management information systems and project management studies. Erin, welcome.
Thanks, George. So happy to be here.
Glad to have you here. Well, I gave a general overview. I'd like you to start with a little more detail about what brought you to where you are now, and then we'll go into what you do now. So how did you end up at Epiq in the role that you have?
So it's a long, though not winding story. I started right off of college campus in eDiscovery at another provider who no longer exists.
Okay, I'm going to pause right there.
Okay.
We have finally reached the place in this industry where we have people with 15 years of experience who started out in eDiscovery right out of school. How is it that happened, even that right out of school part?
I was very lucky to be recruited by a consulting firm that had eDiscovery and a number of other expert consulting services. So they had a robust campus recruiting process, and they recruited me. I had no idea what eDiscovery was. Relativity didn't exist back then. So I remember my first day on the job being handed a concordance database and some production instructions to go QC, and off to the races I went at that point. So I had truly no idea. And then tables have turned, and I've had a lot of opportunity to recruit fellow Demon Deacons and other college students into the industry. And I think they're still as blind today as I was 17 years ago when I made that choice.
So you were recruited right out of school, right into eDiscovery, given a concordance database and told, good luck, go for
Pretty much. Pretty much. There were very robust instructions. I think they were 35 pages long at the time of all the steps to take. But it was definitely a trial by fire to start, but it caused me to learn a lot and to grow in my career pretty quickly. So I stayed the majority of my career there, moving from an entry-level position to running a number of cases, some of the largest second requests in the industry. And so the opportunity at Epiq presented itself to come and lead and grow this antitrust business. We've been really successful the last 18 months, and now, kind of fresh off the presses, it's now a global investigations group. So antitrust is one of many focuses that we have within that business. So it's been a really great opportunity to pivot from learning and doing the day-to-day, which I think gives me a lot of respect for those PMs still doing it, but now to develop the strategy as we move forward as a business.
How long ago did you join Epiq?
I've been with Epiq for about 18 months now.
Okay. And when you came in, the practice you are currently in, was that an established practice? Was that different groups in different areas? Was it all brand new?
So Epiq had been doing work within the second request space and the antitrust space for quite some time, working on a number of very large deals, but it was really formed in the beginning of 2021, and I was brought on to lead it as the practice that it is today. So it had been a bit disparate within the organization up till that point, but we've been lucky to retain a lot of those leaders who were managing the projects and doing the work, and really now diving in to develop the strategy as we move forward.
What does that practice look like today?
So we have experts across the entire spectrum. We have experts who focus day in and day out on these global investigations, on these antitrust matters, including forensics resources, project managers, and client services. And then we have TAR specialists and document review experts as well, who they work, project to project across these antitrust matters. We're really lucky to be able to leverage that experience, identify trends in the industry, and put that best foot forward to look ahead of what our clients are seeing and come to expect what's the next thing from the DOJ or the FTC or global regulators.
If you could sit down with yourself from 17 years ago and say, here's what I'm doing now, what do you think yourself of 17 years ago would think of all of that?
I think she would be proud, but it would also be something that was very hard to imagine. I usually joke in these sorts of conversations that I grew up as e-discovery, grew up as an industry. Outside of that concordance database, I remember sitting in a CEO's office scanning barcodes on hard copy boxes back in the day. So I never could have imagined what e-discovery would come to be as an industry, and certainly didn't at that point see a path forward to what a leadership opportunity within the industry might look like. So I think that she would have a lot of questions if at looking forward to know what it was that this could actually be.
You mentioned something about straight off the presses and global.
Yes, so we are expanding to include a number of additional investigation type matters: white collar crime, False Claims Act, Foreign Corrupt Practices Act, and many other disputes and litigation. So antitrust is now just one of 4 or 5 pillars that we are supporting. It's work that we were already doing. There's a lot of opportunity there to leverage the strategic initiatives that you focus on, and then also responding to regulators. Once you've learned what it is that the DOJ requires, there is nuance between main justice and the antitrust division, but a lot of that is still the same. The impact of technology and what you can do around TAR, what those protocols look like. I'm excited to see there's a lot more opportunity, I think, in these other matter types to go outside the box when we're responding on those matters. So it's really interesting to see, but it's definitely a new development as we grow this practice and continue to look to see what's next for us.
Global also suggests the practice is not limited just to the US. Is that a fair assessment?
It is. So we have practitioners in Canada, the UK. We work a lot with our APAC partners in China and in Australia. And the reality is the work that we do is global in nature. We just responded to a second request that had 7 different regulatory bodies who were wanting to see and investigate the deal. And so that has created a lot of opportunity to work globally across all of our teams and create that global presence for the practice as well.
So I'm going to hazard a not very dangerous guess, and guess that in all of this, you're working with large volumes of data, complex structures of data, numerous custodians, all sorts of challenges, and that you're not doing everything manually to accomplish.
Oh, absolutely not. That would not be possible, though. There are still even the largest of second requests that require search terms and a linear review, but our first foot forward is always to leverage analytics, whether that's a more traditional TAR 1.0 workflow or trying to find ways to develop efficiencies through the review. There's a different calculus that's necessary to determine what's the best solution on any given case. If you're dealing with a very sensitive matter, our recommendation is going to change, because you want to look at those documents regardless of their responsiveness or their privilege content, because you need to understand the business content that might be going out, even if it is still responsive. But then there's a lot of opportunities for efficiencies if you are dealing with a more traditional, if it's responsive, it can go out the door, save privilege. And so there are a lot of efficiencies that we can gain through a traditional TAR 1.0 and then a privilege only review in those instances.
So TAR 1.0, privilege review, what other things are you doing, or what capabilities are you using?
So we work a lot with NextLP and these analytics tools to create trained models based on subject matter expertise, or with our document reviewers, depending on what we're doing, and identify the responsiveness. We try and take it that step further and see how, without a lot of extra lift, we can bring other things to bear in responding, including AI for privilege. We've had a lot of success in identifying privilege content outside of the traditional search terms that might be that would normally be used at, as much as 6 to 12% of the privilege content, even with the most robust of terms, still is not being identified. But by using concept analysis or creating an additional AI model, we're able to identify those documents. And then on the back end of these second requests, or when we're working more in litigation, trying to help with the advocacy support as well. As part of all of these large government investigations, there's usually white papers, interrogatory responses, and those sorts of things that need to be submitted outside of the more traditional document production. And so our team is able to work with that and ensure that we're finding those most important documents, what could be used as your exhibit list, and taking that information and bubbling it to the top as quickly as possible in the case or in the response for the team. And so that's been another place that we've added a lot of value to our clients.
So you packed a lot. A fairly short answer there, at least in the amount of time. Let's see if we can break this apart a little bit and look at some of the components more closely. I think early on in the you said something about building your own AI models and deploying those, right?
Mm-hmm. Yes.
There will no doubt be some listeners or viewers who've built AI models of their own, but many, many more who have not. How does that process work?
So it's really quite straightforward. We identify a sample of documents. Well, taking a step back, we actually want to know how responsive the data set's going to be. So we start with a prevalence sample, and then we take documents and begin to train the model. We work with outside counsel and subject matter experts there. We work with in-house counsel if it's a litigation or an investigation, or even just an internal analysis to understand what's going on, but make an up or down decision. Is it a responsive document? Is it a privileged document? Yes or no? And so that begins to be fed into the technology. The technology learns more, and then that allows it to start making an identification and determine what you want to look at. And you continue to refine that process to make sure that you're getting all of the documents that are going to be of interest in the matter, whether that's to a regulator or to a civil litigant that might be on the other side of the table.
Would it be fair to say that a TAR process, whether 1.0, 2.0, or whatever other number you care to assign to it, any of those processes really is creating an AI model?
So it's using the algorithms that already exist.
Okay.
And so that's but it is learning what's specific to it's learning what's specific to the case and the nuance of the company that's being investigated, the nuance of the deal. What might be responsive in one case or to one subpoena is not necessarily responsive in another case. So that is where it's really figuring out, in my view, what is unique and specific, and kind of building upon the learning and building that model in that sense. You wouldn't take a model for company A and necessarily apply that to company B without further refinement.
But could you? I mean, could you? So here, I guess my inelegant way of trying to get at this question, let's see if I can get there, which is that you could either create models, use them once, and then dispose of them, in essence, or you could create a model and then take that model as a starting point in another part of the case or matter, or in a completely separate matter, and then use that to build upon from there. Do you do all of one, all of the other, some of each?
I think some of each would be the best way to describe it. Obviously, the most value is when you can take what you've learned in one instance and apply it elsewhere. So especially when you're working with serial acquirers, working with the same company, even if the issues are different, what makes the document privilege may stay the same. So that's another indication of where you can reuse what you've learned or reuse those models and apply them elsewhere. Oftentimes when we're dealing with a second request and it's kind of a one and done, that is an instance where you build the model and you move on, but certainly looking for opportunities. And that's, a big bet that we're making on what's next in the industry as far as the acceptance of AI is beginning to build these repeat models that can be leveraged for clients to make sure that you're taking what you learned in a deal or a litigation and applying that in future cases as well.
These models can be used for I'll call it general purpose of trying to find something that's relevant or responsive or some criterion like that. They can be used as well in other ways.
Absolutely. We've done a lot of work to identify hot documents, documents of interest. I had mentioned advocacy support earlier. So trying to help figure out not just is it responsive to a broad set of subpoena requests or document requests in an RFP, but is there something that's particularly nuanced and special? And let's go find more like that. And I think what's really great in those opportunities is you only need a handful of documents. You only need 2 or 3 exemplar documents, and you can still apply the technology to go find more like that. And that is the way in which we're able to get to those key issues as quickly as possible. We found that that's really helpful when you're dealing with litigations with the DOJ, and especially if criminal charges are on the line, but to have that race to leniency. What is it that's most important in this case that will help us assess the risk that we're facing, make that determination if we need to go forward to seek leniency and cooperate, or do we think there's something here that really helps us defend our case? And then go find more like that so that we can be prepared as we're moving forward with the case. And so it's a great partnership between provider and counsel and the corporation to make sure that you're that triune of figuring out what's best and in the best interest to meet not just the letter of the law, if you will, or the letter of the RFP, but really understanding that risk component separately from that.
You mentioned a couple of times in there right to leniency.
Yes.
What does that mean?
So the race to leniency under the DOJ protocols in place currently, though they are up in the air as recently as earlier this year, they've revisited this. But the DOJ does allow a corporation, if they have been suspected of some sort of improper conduct, especially in the antitrust space, to come forward and share that information and share what it is that they feel has been happening, and then how they're preventing it. Most important is that you're then not continuing that improper conduct. And that can provide leniency, especially in these large cartel or wage or price fixing type matters. There's usually a company that's come forward and agreed to leniency, and they're then a friendly witness, if you will, to the DOJ in those instances. So understanding that fast, it really is a race. It's who gets there first. They're not going to extend that to all of the co-defendants. So you have to be the first one knocking on the DOJ's door with really substantive and important information at the right time.
You back to the unpacking. It also mentioned something about using AI and other analytic capabilities to more effectively identify privileged content. Talk about that some more.
Sure. So, as we've been working on these cases, we do always use search terms. It's oftentimes the fastest way to get at what's potentially privileged. But you can take it a step further and apply analytics to parcel even within that parcel out in that potentially privileged population what is most likely to be privileged, whether that be domain analyses or running these privilege AI models. So the same technology that you would use for an up-down responsiveness determination and in parallel, so with very little lift to outside counsel or the corporation, make that same determination, are these documents privileged or not? And we've seen a lot of success. And I mentioned earlier the stat, I think it's somewhere between 6 and 12% of truly privileged content that needs to be logged and properly withheld is not hitting on even 250 term long lists of privileged terms. They're being missed because, a misspelling perhaps, or some concept that's being missed. And it also helps us on the reverse side to make sure that those overly broad privileged terms, that we're actually finding true privileged content. So it provides, again, an opportunity to consult with counsel and the corporation to make sure that we're not reviewing unnecessarily on documents that are, or on term hits that are not likely to be highly privileged. And so we can prioritize our review effectively, making sure things that are truly privileged are getting to the privilog process fastest, and making sure that those documents or those terms that are unlikely to be privileged despite, a footer notation or some inclusion of a search term hit, but really we're not seeing much return on that investment. We can prioritize that later in the process. So it creates a more efficient review and allows us to manage the timelines more effectively.
Identifying privileged content can be a notoriously fraught exercise, and one that can challenge even the most experienced attorneys. It isn't always sufficient, of course, as you know, to use keywords or the law firm domains. You've got to figure out whether it's a communication between an attorney and a client about a certain type of topic and all of that. How are you able to use AI and analytics to help with those parts of attempting to sort between privileged and non-privileged communications?
Sure. So that is where it gets a little bit more complex. But the great thing these days is with NextLP and the tools that are out there, it also evaluates the metadata. So that becomes part of the analysis. So as the model learns, it starts to recognize those third parties that might break privilege and push those to the side. There are additional QCs that are more traditional search based to make sure that those are there. But if there's that contract or that language that is always going to be privileged, you can find comfort that that's being found and then leverage the technology to QC those determinations. If something is scoring very high in a model for likely privilege, but we've coded it not priv, it can go through an extra set of review to make sure there really is that third party on there that's breaking privilege, or there's a reason that we've gone against what is substantively a privileged document to downcode that, or vice versa. If there's something that just nothing about it looks privileged according to the model, what in the world is it making that's making the decision to make it a privileged document? Because one of the things I'm seeing is it's not just making sure on behalf of the company that you're withholding the right privileged documents. The agencies are becoming smarter about realizing when you're over withholding and trying to push back on that. So leveraging the technology allows us to also be prepared to make sure we're not over privileging documents. And by using these models when it's scoring very low in the model, it helps us know that, maybe this one doesn't belong in the log, or we need to take another set of another look at it to revisit what that description is, make sure it's very, very clear with the information provided on the log that it's truly a privileged document.
I would imagine that with the types of matters you're talking about, there is often a sense of great urgency. It's not something where you have you're able to adopt a leisurely pace working through the materials. How, in what ways does the use of these types of technologies help you get to the finish line faster or fastest?
Sure. So a lot of it is around that prioritization. If you know that, because everything, even when it's fast and needed tomorrow, everything still is happening at least in a somewhat linear way. You need to get the not privileged documents out first, and then there's usually additional lag time behind that the privilege log can be produced, whether it's a second request, a criminal litigation, or something that's just between two private litigants. And so because of that, you can use these tools to drive that efficiency. It allows us to make sure that those documents that are not a search term hit and then are also low scoring, let's just get them out the door. Let's do that as quickly as possible. They're low risk. There's not a lot of concern in getting those out the door. You can also, from the responsiveness side, prioritize what you're reviewing there, layer in whether it be privacy or hot or other issue analyses to make sure that you're taking the time that's not needed to look at what's really going to cause concern, whatever the issue might be, and then getting that stuff that's low hanging fruit out the door. That usually, if it's a non-second request, because that's such a prescribed process, but outside of that, it usually allows you to gain a lot of favor with the other side if you're producing those files, which then makes the negotiations a lot more collegial in my experience. And so that then allows for more time where it really matters, whether it be business secrets, privilege, privacy, all of those issues that are longer to complete. And so it opens those doors of conversation when you're getting data out as quickly as possible.
These technologies might help you get to the finish line much faster, but they don't do that work all by themselves. We need to have people involved. What do your teams look like in terms of the makeup, the number of people, the expertise or experience?
So everyone on our team has been working for at least the last 3 to 5 years on these large global investigations. We've done over 50 second requests and other merger control investigations just in the last 18 months. And so everyone on our team has that deep bench of experience. And so with that, it helps them understand where there might be pushback from the agencies. They understand the trends. And so that team is made up of forensics experts who understand the impact of refresh collections. They understand the delays and the nuance of collecting emerging data types. And then that feeds into our project management team, as well as our advanced technologies or TAR team, as we colloquially call them, and then the document review team. And the great thing is we work collaboratively across all of these things. So I mentioned, teams or emerging data, and with that, there's an analysis. Can that go through TAR? Can you do a roll up and get enough context and enough physical text, enough characters that'll allow a TAR analysis across those? And so when we're working across this dedicated team, it allows us to understand how we collect the data impact how we can review the data, which then is going to impact how we can produce the data. And so we bring this holistic approach to everything that we're doing with a specific lens to these large global investigations.
On the one hand, you're trying to bring to bear these teams and this technology to get through sometimes massive amounts of data very quickly and without disruption or delay. On the other hand, you're dealing with regulators who might have a different view. What do you do to avoid delaying discussions with regulators, or if not to avoid them, to navigate them successfully?
So our strategic philosophy, if you will, is that we never want the ESI negotiation to be where our client loses points, because any negotiation, especially with the regulator, is a give and take. If counsel wins on this point, then the DOJ is likely going to dig in on another point. And at no instance do we want the ESI process, whether that be how we process data, the TAR protocols that we're going to use, any of those items to be what keeps them from winning where it really matters. And so our effort is always to go forward and make sure that our technology, our processes, our workflows comply with what both the DOJ and the FTC, or the CMA and the European Commission, globally, what they want to see, so that it's, very much a checkbox, and it's not a fight that has to be fought unless there's a strategic reason that the law firm wants to do that. I've seen a lot of instances where cases get so hung up in trying to negotiate the TAR protocol that you're 6 weeks into your 12 to comply. And what do you do then when you're having to take what's already almost impossible and make it fit into half that time? So we want to be able to get ahead of that and make sure that what we're doing isn't the holdup.
Well, you're dealing with a big problem then. That's what you're doing. A much bigger problem than you had before. You must, that means, have some equivalent to a library of materials about how to address those different points with each of the different regulatory agencies you're dealing with, because they can't all be on the same page, are they?
No, they are not, though we are seeing a trend towards complying more and more with the DOJ's protocols, especially around TAR, but in many other ways as well. But we have playbooks, we have repositories of kind of template response letters, because while what the expectations are with each regulator may not be the same, how they want it documented typically is. So we know you're going to need to address the deduplication process. You're going to need to address near dupe or email threading identification. You're going to need to address your technology assisted review protocol that's being used, who it is that's doing that training. So there's a list of things they want. What they want it to say may vary, but usually it's the same 8 to 10 items that they're always wanting responses on. And so knowing that for the CMA it's this, and for the FTC it's that, is usually one of the key ways that we're able to do that quickly and seamlessly.
Well, Erin, thank you so much. Erin Toomey is a senior director at Epiq, where she leads the antitrust and competition practice group. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. And Erin, again, thank you so much.
Thank you. Really appreciate it.